Hey guys, if you're just logging on, we're just getting everybody on here. So just bear with us for a couple minutes while everybody gets allowed into the meeting. We want to make sure everybody's here before we start. And if you guys have questions, feel free to type them down at the bottom of your screen. We'd be more than happy to answer those as they come in.
Go ahead, Patty.
You're ready for me?
Yeah.
Okay, so first and foremost, and I'll mention this a couple of times today, so forgive me if it gets to sounding old, but you can go on my website on widgetsway.com to sign up for Bringing 2020 to a Close, which is our webinar. I believe we're doing on the 30th. No, is it the 29th, Hootie? I forgot.
30th.
The 30th.
At noon.
The 30th at noon, we're doing a webinar called Bringing 2020 to a Close. We're going to talk about everything that we've been through and what's projected that we're looking at. And I'm going to give you guys a little bit of an insight as to what to expect in that Bringing 2020 to a Close, because yeah, don't shoot the messenger, okay? Because what I'm about to tell you guys is not good, but I need to make sure we're all on the same page, reading the same book. So please, I encourage you, sign up for the webinar on Widget's Way for Bringing 2020 to a Close on the 30th at 12 noon. Lots of good information there. We may even have a guest speaker. I'm going to see if one of the attorneys can join us as well. So first thing that I want to tell you guys is big deep breath. Sorry. Back in March, everybody rewind your own brain, okay? So that I'm not putting words in your head, but you're gonna agree with me. I'm trying to take you back to March of 2020. So let's go back to the first part of this year when we were originally placed on the order to shelter in place from the government. If you guys all recall, we were told that we were gonna be ordered to shelter in place for 3 weeks back in March. Okay, so for 3 weeks back in March, we were told that there would be a lockdown. Here we are several months later, still on lockdown, and now being told again, 3 weeks shelter in place. Take that for what it's worth. Can I tell you it's going to be 3 weeks? I know they're all saying 3 weeks, but it was 3 weeks when all this started. So just something to think about and keep into mind there is how honest are they being with us is hard to tell. Looking at the numbers and the amount of people that are being infected and seeing everything higher than it ever has been. Our numbers are off the charts. I don't think 3 weeks is long enough, but that's just my personal opinion. I don't think 3 weeks of lockdown is going to fix this. I don't think 11 months of lockdown is going to fix this. Okay, just saying. So please keep that in mind. We're back on lockdown for 3 weeks, although I'm learning very quickly that our council members and our legislative staff cannot count. In my opinion, they may be similar to contractors because they can't give us a good solid schedule either. And that has nothing to do with the contractor. I get it. Parts are delayed, things are delayed. I'm just saying. Usually it's longer than the original estimate of time, and our legislative council is proving to be the same. Just saying. So a couple of things that I want to tell you, and please don't shoot the messenger. LA County courts are currently not issuing defaults. What does that mean in English? Default on a case is basically your tenant didn't file an answer, and now your legal counsel needs to tell the court to declare a winner and issue that writ of possession and that money judgment. They're not doing that right now. LA County is not issuing defaults. Okay? Big hiccup and a slowdown in your current eviction cases. Number 2, LA County is currently setting dates for trial, but they're setting trial dates after January 31st of 2021. So anybody that thinks that they're getting to trial prior to the end of January of next year, by the end of this year, unfortunately, you're probably sadly mistaken. LA County courts are issuing trial dates, but they are after 1/31 of 21, just so that you are aware. Why am I talking a lot about LA County? Because LA County currently is the most restrictive. And usually lawmakers look over the fence when they start looking for what they should be doing. So LA may be setting the example for other courts and other counties here in the future and going forward. And this is all of LA County, okay? Just so that you know. Please take in mind when you're serving the 15-day notice to pay rent or quit, it is a requirement anytime you're asking for money right now, whether it be on a 15-day notice to pay rent or quit, or a 15-day notice for a curable breach of covenant for monetary value. So any money that's owed for utility bills, late fees, it's all on a 15-day notice now, not on the same notice. One's for pay rent, one's for a breach of covenant, okay? But anything that's monetary has to go on a 15-day notice. For regular breaches, a 3-day curable breach of covenant is allowed. That would be failing to allow entry, any material breach of the lease. Just saying. So with those notices, we do have to disclose the COVID Tenant Protection Act. So we're basically telling our tenants what the rules are and when the rent's due. When we serve that, we're required to by law. It is mandated. So don't think that you can just go post that 15-day notice and not have to deal with notifying them of what their rights are. That's not how this works. If you don't notify them of their rights, then they weren't properly served and you have a hole in your case. Okay.
Patty, we have a couple questions. Do you want to take care of them before you continue?
Sure. Before I go forward, what you got for number 1?
Do I serve all tenants on the rental agreement with a 24-hour notice to enter, or serve one on behalf of all?
No, you want to name as many people as you possibly can on every document that you do. And let me put it this way. When you're serving the notice, the whole rest of the basis of the case depends on that notice. So if you didn't initially name them there, it's going to be very difficult for you to add them in later. So you want to name everybody on the notice. We can always dismiss people later, but we want to name everybody we possibly can. We want to stick our teeth into everybody. Next question.
Should I keep giving my tenant 15-day notices after I file the complaint, or will it void my complaint?
It voids your complaint. Any notice that you serve supersedes all other notices. So when you serve a notice, and I'll give you an example, okay? I serve a notice to cure or quit, okay? And then I serve a new notice. That voids the notice I already have in place. I serve a 3-day for rent. I'm sorry, I serve a 15-day notice for non-payment of rent, and then I go forward with adding that 15-day notice, and maybe they made a payment. That 15-day notice is gone. If I'm serving on the balance, then that notice now supersedes. So anytime you serve a notice, it should supersede all other notices. So the most current thing you do. So if you're in a court litigation on a specific notice and you serve something new, you void everything that's in the court case. The new notice now controls. You have to start all over again. So we don't want to serve anything unless our attorney, legal counsel tells us to. Most of the time it would be a 24-hour notice to enter or something like that, which doesn't take precedence over any of the rest of it. Next question.
Assuming late fees cannot be included on 15-day notices, correct?
Wrong.
I think you were talking about the 15-day notices.
So I got you. There's 2 different 15-day notices, just so everybody is aware. One is for non-payment of rent, which is where your rent goes. And the other one is a 15-day curable breach of covenant. That is where you would put late fees, utility charges, fees for charging back a broken window, anything monetary that is not rent goes on a 15-day covenant notice. So you can serve both notices at the same time. Late fees are allowed to be charged to the tenant starting in September of this year during the COVID period. So March, April, May, June, July, August, no late fees are allowed. It's the way they wrote the bill. Don't shoot the messenger, call the governor, bitch at him. Okay. I didn't do it. But September, October, November, December, January, you can charge late fees there. They just need to go on that 15-day curable breach covenant, cure or quit, tomato, same document. People use different names. I get it. The legal term is a curable breach of covenant. So you may hear me say that. You may hear me say cure or quit, because I know that's the slang and for us property managers. So just keep that in mind, okay? Only rent can go on a notice for rent on the pay rent or quit, okay? All other monetary damages, meaning all other money charges, go on that curable breach of covenant. Do we have another question?
Can tenants deny entry for an appraiser or a repairman due to COVID?
Kind of. The key word there was kind of. Okay, so if you're serving a 24-hour notice to enter and they won't allow entry, you can attempt to do it again at a later date. If they're still not allowing entry, I would talk to your legal counsel. But for the majority, what we're seeing is then we're doing a 3-day curable breach of covenant for failure to allow entry, which is a violation of California Civil Code 1954. So it's actually a law that if you serve a written notice, they must allow entry. And we are seeing successful evictions on that. The argument is, if I, as a landlord, have a responsibility to provide habitable premises to the tenant, and the tenant won't let me in to make sure that the unit is habitable, how could I possibly do my job? Okay, so you do have an opportunity to do that there that way, but this isn't something you want to attack on your own. You want to contact your legal counsel. You want to, because each county is a little bit different. Okay, LA County is very, very pro tenant right now. Riverside County is starting to be the same damn way. San Bernardino County, not at all. They are pro law, pro landlord. Okay, so it just depends on where you are, what the property is, and what the situation is. Okay, so if they're not letting you in because they have COVID, then what are they afraid of? Giving it to someone else? Nobody seems to be afraid of that for any other darn reason. Okay, just saying. So you want to be careful with that as well. So contact your legal counsel. Hootie, do we have another one?
Rent control proposition was shot down by the voters in 2018. How did the state assembly have the power to supersede the will of the people in the passage of AB 1482?
That would be Governor Newsom. And I think he should be holding targets at the shooting range. Just my personal opinion, okay? The guy's off his rocker. He's trying to shut the little guy out of business, and unfortunately, he's succeeding. I have a question for you. How come Lowe's and Home Depot can be open as an essential business during a pandemic when we're supposed to shelter in place, but the mom and pop hardware store can't be open? Can you explain that? See the problem? Okay, it has to do with your governor. Governor Gavin Newsom is very, I'm not even gonna say it because it's just bad. My personal opinion is bad and it makes me look bad if I express it, but he has the power to write assembly bills, Senate bills, etc., and to pass them through as law without letting we the people vote on them. Here's something that you need to understand, so maybe you have a little bit better understanding of why. If you look in Irvine or in Hollywood or anywhere for that matter, we have huge apartment communities, huge. I mean, 1,500 units, okay? 2 or 3 people own those to 1,500 tenants. But those 2 or 3 owners, they don't just own that one apartment community, they own 30 of them. So now they have 30,000 tenants for 3 owners. What am I trying to tell you? In the state of California, we are 78% tenant occupied. So they are making laws to support the majority. We are the minority. We are the little guy. We are getting run out and pushed out of business. Maybe that helps put things into perspective as to why he's able to write those laws. He's going on the majority. He's supporting the majority, so the majority continues to vote for him. Simple politics. It's bureaucracy and bullshit at its finest, okay? I'm just saying. Anything else before I move forward?
No, continue.
Okay, I'm continuing on. If you guys don't fully understand what happened with AB 3088, and mind you, the statewide rent control initiative of AB 1482 is 9 pages long. It's about 8.5. Let's give it 9 pages. So for the entire state to be susceptible to rent control, the bill, the law that wrote that is 8.5 pages, almost 9 pages long. For AB 3088, which is the COVID Tenant Protection Act, it is damn near 40 pages, 40, okay? It covers a lot of things. They've implemented a 15-day notice. We've been fighting in legislation for the past 4 years to not have a 15-day notice, that it's unethical to us as landlords. Because now the whole month's gone before we can start the legal process, because we also can't count weekends and holidays or court closures. Okay, with all that being said, we need to be extremely diligent on what we do. What we're doing right now is a game of chess, and we need to take every piece and move it with precision and accuracy. This isn't, oh, I'm just going to do this, and oh, I'm just going to do this, and wait until I get into court, because I'll tell you right now, the judges are throwing the weak cases out of court. Weak cases are not even being looked at. And I'll give you an example of what I mean. If you file an eviction based on the tenant violating a written term of their rental agreement, and the written term of their rental agreement is cleaning, okay? Everybody has a different yardstick of cleaning. And if you don't know what I'm talking about, ask your own kids. Their idea of clean and your idea of clean are 2 totally different things, right? Right. Landlord tenant, same concept. So cleaning becomes a matter of an opinion. So if you get into court on a notice that your tenant isn't keeping their unit clean, you better have photos that they're hoarding, and not that they just have dirty dishes in the sink, because dirty dishes in the sink mean that they live there. See what I'm saying? When you get into court right now, what you're asking that judge to do is you're asking them to defy a government order to shelter in place based on what's happening in your property. It better have some pretty big teeth and some pretty big claws. We're talking police reports, harassments, arrests, drug use, gang members. I mean, it's got to be bad, you guys. Or you need that long laundry list of everything they're doing wrong, not just the little things, okay? Example, unauthorized pets, unauthorized occupants. I'm going to give you 3 more, okay? Modifications to the property without written consent of the landlord. Let's just take those 3 issues and put them in case. And you say, okay, I'm just going to get them on the unauthorized occupants and the unauthorized pets, because that's an easy way to get them out. And you file that with us. We talk to you, you get into court, and the tenant says, that's not unauthorized occupants. Those are my caregivers. That's not an unauthorized pet. That's my emotional support animal. I'm disabled. Now, where's your case? What? Oh, you don't have one? See the problem? You guys, you got to have teeth in there, okay? And just basing it on their cleanliness or one thing is a bad idea. A better business practice in the event that you're going to attempt to do the legal process is that you have a long laundry list of not one thing they're doing wrong, not 5 things they're doing wrong, of everything they're doing wrong. Let your legal counsel pick out and detect what has more teeth and what doesn't, because I'll tell you right now, it's above your pay grade and it's above mine. Okay. Let the attorney decide what they want to argue in that courtroom with that judge. They know them better than any of us, and they know what's going to have teeth and what isn't. So we need to listen to them. Even if we think something has more power, they're the professional. Let them figure it out. Let them decide. They are way up here on the pay scale. Okay. So with that being said, let me say this. On September 1st, the governor passed AB 3088, and we're going to talk about that a little bit now and more on the 30th when we close this out at the end of the year. So please sign up for that webinar. Just go to widgetsway.com, banner at the top of the page. You should be able to sign up there for the webinar. We're going to go into detail about AB 3088, how we see and foresee it being extended and what those terms are. We're going to give you a legislative update. We're going to give you a court update. We're going to give you all kinds of information. So please, please, I beg you, sign up for that, bringing 2020 to a close. You may find it extremely informative. Okay. Now, let me get back. On September 1st of this year, they passed AB 3088, and us as property managers and us as landlords can all agree with one statement that I'm about to make. For the past 20 years, every time we contacted our attorney and told them about all the horrible things our tenants were doing in the property, they always said the same thing after they listened to the huge story. But do they owe the rent? Forget the drama. Let's go after the rent. That's the easiest way to get them out in California. I'm here to tell you that AB 3088 has shifted that planetary alignment. It's gone, okay? The money is now the hard way. When you start talking about money, that's when all the COVID protections kick in. If they're dealing drugs, doing something wrong, having arrested the property, becoming a nuisance, disrupting the right of quiet enjoyment, you want me to keep going, or you know the terms of your rental agreement better than I do? I'm just guessing here. That has more teeth right now than the money. So document the money so that when it's time to go after the money, you have all your ducks in a row. But if you need to sink your teeth in, sink it into the drama. And I'm speaking to you from experience. We used to tell people the drama is the hard way. It's the hard way because you have to have all your documents in a row. You have to have all your ducks lined up. And I'll give you an example. You do a 24-hour notice to enter and they don't allow entry. Now you're doing a 3-day curable breach of covenant with a new 24-hour notice to enter on the 3rd day. You go there and they still don't let you in. That's a call to your legal counsel. How many covenants do I need in the county I'm in order to do an eviction and it have enough teeth? In LA County, your attorney might tell you that that's 3 times that you do that process before you serve them the 3-day to quit. In San Bernardino County, they may tell you 1 and done, okay? So again, I can't tell you, you need to ask your legal counsel for your county you're in your court, how many notices you need. It varies by area, just saying. So you may have to do that 3-day curable breach of covenant 3 times with a new 24-hour notice to inspect each time to see if they're allowing entry, to see what's going on. And I'll tell you right now, you can't get to court and say, oh yeah, Your Honor, because what happens is opposing counsel will ask you, when did you re-inspect and where's your supporting documentation? You do not want to look like the deer in the headlights right then going, what is he talking about? That would be your 24-hour notice to enter. You have to do that behind. Remember I said this was a game of chess? Each one of those documents has a place, and those all need to be in order for you to have enough teeth to evict them for cause right now. So I know building a case sounds like it's so simple and so easy. No, it needs to be done with precision and accuracy. There's no room for error here. Costs you the 2 most expensive things in this business. One is time and the other one is money. And quite frankly, we've spent enough of both of them already, right? Just saying. So make sure that you're building your cases on drama. They have enough teeth and you're communicating with your legal counsel. That's the most important thing you can do. They know better than anybody what you can and can't do and where you can and can't enforce things. So be careful with that. Before I get on to anything else, Hootie, do we have more questions?
Yeah. Do you recommend serving 15-day notices for record keeping purposes? Because actual evictions are extremely difficult right now anyway.
Actual evictions aren't that difficult if you're going after cause. It's when you start talking about the money that all those protections come in. So if you have a case that you could file based on police reports, failure to allow entry, a nuisance at the property, I could go on forever, but you know your terms better than I do, so I'm guessing here, okay? Document the money by all means, but know this, what it says is 15-day notice. All they have to do is say they were affected by COVID, and 25% of the rent becomes due on or before January 31st. Okay, so the rent's not even due yet, you guys. We've all been affected by COVID. Did you guys have to buy a mask? Do you have to wear that when you go out in public? Affected, not infected, affected is a big, broad term, and it allows for a lot of argument. Were some people affected more than others? Absolutely, but you were still affected. You with me? So technically, no, it's not a waste of time to serve that 15-day notice, because when we can go after them for non-payment, all your ducks are in a row. You did your job. You made it easy for your legal counsel. Got me? So we don't want to not do it, but I wouldn't attempt to enforce it, is what I'm saying. And that's just my opinion. Have your paper trail, have all your ducks in a row. You did your job. That's the most important thing. Okay, everybody got that? So very important that you're documenting the money, but in the event that you need them out, I would serve a 24-hour notice to do a preventative maintenance inspection. Go in there and make sure there's no habitability issues. And while you're in there, look for lease violations. Very simple. If you don't have any lease violations, buckle up. This is going to be a hell of a ride, because God knows how long this 3-week lockdown is going to last. Just saying. Okay, give me some more questions, Hootie, and then I'll get on to the next step.
When posting our rent, should we continue posting to the earliest amount of the rent owed, or do we post it to the current month?
You want to post all the rents that are owed. Okay, and if they pay you 2 months of rent right now in December, you don't want to apply those to November and December. You want to apply those to March and April. You with me? So you want to apply to the past due balance first. And the reason why I say that is when you get into eviction court for money, you can only go back 1 year on your notice. Okay, everybody got that? So if you make them pay off the most current rent first and leave those past due balances, over a course of time, you won't be able to evict for them if they've been over 1 year. Okay, so you always want to apply to the oldest balance first when you have money coming in. I hope that makes sense to everybody. Okay. Do we have another question, Hootie?
What if I can't serve 15-day notices because I have a complaint open?
What kind of a complaint? With the city? Contact your legal counsel. I don't know what kind of complaint you're speaking about. A complaint with the city?
Eviction complaint is what he said.
I don't know what an eviction complaint would be. So I would definitely talk to your legal counsel and ask them if you can serve a 15-day notice to pay rent or quit. The only time that I'm aware is if your house is in RUBS, RUBS, that you cannot serve notice to them because technically they don't owe rent. I see people asking questions about the 75%. That's what I'm going to talk about next. So stay tuned, you guys. It's about to get really, really interesting. Do we have another question, Hootie?
What evidence do you need to show illegal occupants in the property?
It's hard to prove illegal occupants, and I'm being very honest with you. Personally, if I remember, I'm not an attorney. I'm a lot of things, but I'm not an attorney. If I was trying to prove unauthorized occupants in the property, what I would do is set up a camera system. I would hire, and this is me, okay, not you, I get it. I would set up a camera system. I would actually hire a camera company, and I know of one if you guys need one, and a security company that monitors those so they could testify in court as to the unauthorized occupants. That way it wasn't just me. I had a third party telling the court what's going on there. Does that make sense to you? Proving unauthorized occupants is hard. Again, it goes back to the terms of your rental agreement. How long can your tenant have a guest and it not be considered an unauthorized occupant? Most of you have in there 14 days. A guest can stay no longer than 14 days. It's probably a term of your rental agreement. Mine says 3. You know why? It's a heck of a lot easier to prove that they've been there longer than 3 days than it is half a month. So just saying, You may want to consider changing that going forward, but it's really hard to prove unauthorized occupants. It really is. I'm being honest with you. And with everything with COVID and the this and the that, it just doesn't have as many teeth as it used to prior to COVID. Unless, of course, they have a building and safety issue where they have 19 people in a 600 square foot property. That's a violation of building and safety standards. Just so you guys know, that would be 690 square feet is for 9 residents, according to California Building and Safety Code. Isn't that ridiculous? Next question.
Can I evict my tenant if I am planning on selling my property?
Yes and no. You want to shoot me now? I'm just kidding. The loophole that seems to have the most teeth right now that isn't in AB 3088 and where we're seeing the most success is if you are in escrow, you can serve a 30-day notice to terminate tenancy and continue on with an eviction if they don't vacate in 30 days. The key there is escrow has to be open. Okay, everybody got that? Not I'm gonna sell, here's a 60-day. Escrow has to be open. Once escrow's open, you can serve that 30-day notice. As a real estate broker, I am suggesting that you hypothecate. I know it's a real estate term. Hypothecate the notice through escrow. Also means assign. Hypothecate means to assign. That way you're assigning your notice to the buyer. And I'll give you an example. I'm selling my house to Hootie, who's my moderator, and I love him. And there's tenants in there. So I serve the tenants a 30-day notice to vacate because the house is in escrow, and I can do that because I'm the owner of record. Okay? I don't assign it in escrow. So now Hootie doesn't have my notice. And as soon as escrow closes and it's his house, he serves his own notice. The problem is escrow closed. Your case just died. You don't have the loophole anymore. So you need to assign that notice so that your buyer, Hootie, can pick that notice up and continue forward with the eviction based on the fact that the notice was served in escrow. That's your loophole, okay? Everybody got that? Escrow is your loophole. 30-day notice, and make sure you assign it to the buyer, or it can become a nightmare. Trust me. Anything else? One more question, and then I'll get on to the next step.
30-day, even if the tenant has been on the property for over 10 years, sorry.
Escrow has a different set of rules and a different set of facts. It has to do with our rights as humans. Nobody can tell us we can't sell. You know, if they told us you can't even do this through escrow, then they're basically controlling us in a democracy. Okay, we're not a democracy yet, although we're headed that direction. Just saying. So we still have rights as a landlord to sell our properties. So that is the one loophole that we have in the justice system currently. I'll do one more question, and then I'm going to move on to the 4 easiest ways to get possession of your property right now. And then we're going to talk about AB 3088 a little bit more, and then I'll take some more questions. So do we have another one, Hootie?
Let's continue.
Okay, we're continuing. 4 ways that are the easiest, simplest ways right now to gain possession of your residential dwelling. Number 1, you can shoot them. Yes, I did say that. I'm not suggesting that you do that. The law firm I work for cannot represent you because they don't practice criminal law, but it's quick and it's easy. Just saying. And the police are on a no arrest hold, so you get a ticket to come back to court later. Okay? Don't go shoot them. I'm trying to be funny, you guys. Okay? But it sounds great, doesn't it? Number 2, you can build a case on cause. Okay, remember, technically the money's not due yet. All they have to do is sign the declaration or say they were affected by COVID. And the truth of that is We've all been affected, okay? All of us, every single one of us. There isn't one person here on this planet at this point that has not been affected. We've all been affected. Affected, big broad term. Remember, we talked about that earlier. It's easy for anybody to argue that in court. So it all comes down to how well your attorney argues. That's not big enough for me. So building a case on cause, material breach of the lease, police reports, nuisances, and it's got to be bad, you guys. It's got to be bad. If they're hoarding, you need pictures of the hoarding. And please understand that if you're dealing with a hoarder, that is a mental disorder. So you need to be very careful on how you proceed. And I don't suggest you do that without some direction from somebody that has some experience with dealing with a pack rat or a hoarder, because it is a mental disease. So now you're basically evicting someone that's disabled. So you need to have your ducks in a row and make sure all of your lines are straight as far as that goes. Another thing that you can do is cash for keys. I know most people want to shoot me as soon as I say that. My tenants haven't paid in 11 months. Why would I give them money to get out? Because we have to stop the bleeding at some point, in some way or some shape or some form, or we're going to go down. Our ship will sink. Okay. I know it's a hard concept to follow because they owe you 11 months of rent, 10 months of rent, 3 months of rent, whatever it is. I get it. Okay. But we just got put back on lockdown for another 3 weeks. Wait, does that really mean 10, 11 more months? Just saying, something to think about. It may be less expensive for you to pay them $3,000, $5,000, $10,000. I don't know how much your rent is, to get them out now than to continue to battle this for another 10, 11 months. Who knows? How much rent are they going to be behind by then? Just saying. And how long can you hold on to your house without it foreclosing? Okay. So cash for keys is definitely something you can think about. You need to come to an agreement. You need to play nice. Please contact your law firm. They can help you with that. For those of you that are property managers, a couple of things you need to know about a cash for keys agreement. In order to legally arrange a cash for keys agreement, you must be one of 4 people. Okay, one of 4. Only 4 people can do a cash for keys agreement. Number 1, you have to be the owner of record. If there's an uproar in your apple cart and you've offset the balance, the chances of you as a landlord being able to negotiate that are low because you've already messed up the balance and they don't even want to talk to you. Just saying. You can be a licensed sales agent working under a broker. Okay? You can be a broker or you can be an attorney. Those are the 4 people that can negotiate a cash for keys agreement. Why am I telling you this? Because it could be considered practicing real estate without a license. So those of you that are on-site managers, you need to be careful and make sure you're talking to your legal counsel if you attempt to do a cash for keys agreement, and make sure you have the authority to do so. Just saying. My whole thing is protect you, protect you, protect you, protect you. So definitely want to check on that. But as far as I'm aware, it can be the owner of record, a licensed sales agent, a broker, or an attorney. That's it. So be careful, especially for you on sites, or if you're a manager that's not a licensed agent, that can become a problem very quickly. The other loophole we have is eviction in escrow. So if your house is listed for sale, we don't want to serve them notice until escrow's open. It's escrow that's the loophole. And we talked about that a little bit earlier. If it is in escrow, you can serve the notice to terminate and assign the notice or hypothecate the notice to the buyer. That way, when escrow closes, the buyer can pick up the pieces and run and continue on with the eviction based on the escrow. It has to be an escrow for that notice to be served, and that notice has to be assigned to the buyer for them to be able to pick up the pieces. If that's not done, this doesn't work, and everything I just said is null and void. So be careful with that one too, okay? A lot of people say, oh, you know, I served in the notice while we were in escrow, and now the buyer has, escrow's closed, the buyer can't do nothing because escrow closed and they weren't assigned the notice. Only the owner of record can evict. So We have to assign the notice through escrow or it doesn't work. Everybody got that? And when you say to your agent, you got to hypothecate the notice, they might look at you funny. It's a real estate term. Okay, everybody got that? Hypothecate, it means to assign. Okay, so those are the 4 reasons that we're seeing successful evictions or successful possession right now. Actually, it's only 3 reasons because we really can't shoot people. Okay, so cash for keys, cause, and escrow. Those are the 3 things that we're seeing the biggest results from. Okay.
Quick question. If a
Yes.
cash for keys agreement was executed perfectly and the tenant doesn't move out by the agreed date, what is the process to evict and or do a sheriff lockout?
A cash for keys agreement is that it's an agreement. Both parties agree. So you don't pay them any money until they are standing there with the keys ready to hand them to you. Okay. Cash for keys means you're going to give them money when they give you the keys and vacate the unit. So if they fail on a cash for keys agreement, there's no bearing, there's no lawsuit. You contact your legal counsel about getting your funds back in the event that you paid them in advance, but it's a trade, for lack of a better way to explain it. So I might come to you and I might say, hey, I need my unit back for whatever reason. I understand that you're having some financial difficulties with COVID and everything else that's going on. So I'd like to pay you $10,000 if you're out by the end of this month. Oh, sure, I'll do that. Okay, I'll be back on the 31st to give you your money and collect the keys. You go back on the 31st, they're still there, all their stuff's still there. You say, oh, I thought we had an agreement, and see what they have to say. But there's no money exchanged until you have keys and a vacant unit. Simple. I hope that answers the question. So it just depends on what your legal counsel says, whether you have any grounds to continue evicting. I don't think so. Going after your money you paid them, most definitely. Do we have another question, Hootie? Otherwise, I'm going to talk about what's happening with AB 3088 and what legislation updates I can give you.
I filed saying I need to move family in the home. I'm not sure if that's a question or it's just a statement.
I hope it's a statement. It would be a 30-day, a 60-day, or a 90-day notice, depending on how tenancy is held, and taking the property back so you can move back in or have a family member move back in is absolutely a cause, a reason for cause. And you should be able to continue with an eviction if they don't vacate as at the end of their notice. Remember this, don't take any rent past the expiration of a notice. By doing that, you void the notice and you have to start all over again. So be careful with that. Okay. Do we have another question, or I'm going to get on to 3088 and what we're up against, you guys? So buckle up.
Can we evict now if a family member moves in?
Yes. A family member wants to move in, and please keep in mind, depending on the area, it depends on the family member. LA County says you can either go up your tree or down your tree, but you can't go out to the sides. Example, you can evict because your mother, your grandmother, or grandfather, okay, want to move in, or you can go down the ladder to your kids or your grandkids. You can't go out to aunts, uncles, cousins in LA County, or especially the city of LA. Sideways doesn't work. You can only go up your family tree or down your family tree, okay? Other areas are much more lenient. I would definitely talk to your legal counsel about who that person can be and if that would fly or not. Did I answer that one okay?
Let's continue.
Okay, I'm continuing. Okay, you guys, here we go. And this is where it gets real nasty. So please pay attention. I may ask questions later. Just saying. AB 3088 says if our tenant simply clearly states that they were affected by COVID, that 25% of the rent is due on or before January 31st of 2021. At this point, there's no description as to when the balance is due. So after talking to several different attorneys, because mind you, they all have their own opinion, I have gathered that the way it's written right now, the money becomes due the day the bill expires, which would be February 1st of 2021. So when we say that out loud, it sounds great to us as landlords. 25% of the rent is due on or before January 31st of 2021, and the 75% balance becomes due the next day. That sounds great. At least we know we're getting our money. Yeah, exactly. Not happening. Thanks, Ed. If it doesn't benefit tenants, it's probably not going to fly in the state. Just saying, because we're a pro-tenant state. We're 78% tenant occupied. They make all the rules for the tenants. With that being said, let me tell you what legislative updates I have for you. They will be amending AB 3088 on or before January 30th. No, because the 31st is a Sunday, so the 30th is a Saturday. On or before January 29th of 2021, they will amend AB 3088. It is a given, okay? They will amend it. Currently, don't shoot the messenger. Currently, they're talking about extending the 75% of the rent to be due on or before February 1st of 2022. That's scary. That's real scary. Some of the protections that are protecting us as landlords for no foreclosures are gone. And they're able to start filing notices of default. Some of my owners are already getting notices of default. And this is what I mean by stopping the bleeding. Your investment property is your own little ship, right? And right now it's sinking because it has no income coming in. That's scary. We have to stop the bleeding. And I know it's hard to swallow the cash for keys idea because I hear you. I own investment property. I got skin in this game too, you guys. I'm not alone here. And you're not alone. I don't want to say we're all on this ship together because the reality is all of our ships are different, but we're all in the same storm. Okay? I have my own personal opinion that they're trying to push us little guys out of business. And that's just my own personal opinion. But the writing's on the wall. So we need to put our ducks in a row to save our ship. We need to stop the bleeding. The justice system has turned into just us, okay? It is just us trying to figure this out and how we can help stay out of foreclosure, how we can keep our investment. So with that being said, just please, our legislative council is fighting for us in Sacramento. You can donate money to the PAC to help them fight that. But the reality is it's looking like what's going to happen in 2021 may be worse than what's happened in 2020. Okay. And that's just me talking to you. It hasn't passed yet. I'm trying to prepare you for the worst while we all hope and pray for the best, okay? Because sometimes it's so much easier to pretend and hope that everything's going to be just fine and prepare for the worst. Buckle up. This is going to be a ride. If they extend it so that 75% of the rent's not due until 2022, how are we going to make our mortgages? What are we going to do? How are we going to survive? How do we keep our ship floating? So with all that being said, please keep in mind, you do have the option of cash for keys negotiations. You do have the option of escrow, and you do have the option to build a case on cause. If your tenant isn't doing anything wrong except not paying the rent, you may want to review another plan of action. Okay? Because we can't build a case on them if they're not doing anything wrong. Okay. Hootie, do we have questions?
How do we collect the 75% when it's due? Evictions or small claim?
Eviction. Unless they write the way the bill's written right now. And let me just explain your question in detail. From March to August. So the monies that are owed for March, April, I almost said August, March, April, May, June, July, and the whole month of August. For those 6 months of rent, we can never evict. Ever, 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 7 times never. We can only sue them in small claims court starting in March of 2021. Okay. For small claims court, before everybody starts screaming at me, they have limits on them. Yes, it is $5,000 for a business and it is $10,000 for an individual. However, because of AB 3088, they have removed those amounts and made it unlimited when you're going after the rents because of COVID. But you can't even file a small claims case against them until March of next year. 4 months from now, you guys. Okay, just saying. As far as the rent monies owed from September, October, November, December, and January, 25% of that amount of rent is due on or before the 31st of January. And you're most likely going to be able to start legal right after that based on the 25%, not on the full amount. The full amount of 75% is going to be extended. Okay, I'm telling you, it's gonna happen. It's not a matter of if, it's a matter of when. And how they write that isn't gonna be pretty. I mean, the way I see this unfolding, and this is just by looking at other continents that are dealing with this problem, like Italy, that's on round 2 of their lockdown, and China that has had 3 different lockdowns. Yeah, this is going to be longer than 3 weeks. We have the highest numbers that we've had thus far. Why do we think 3 weeks is going to fix that? Just saying. You guys with me? I mean, what they're telling us and what's happening are 2 totally different things. So I encourage you, look at what's happening in other countries, look at what's going on there, and then realize that it's coming here now. Now it's hitting us. Round 2 is hitting us. We're seeing the highest numbers that we've seen. If our original lockdown in March was only for 3 weeks, why are we still on lockdown? And is this current lockdown going to be 3 weeks, or can they not count? I don't know. There's a lot of questions I can't answer because I don't have the answers to them. None of us do. We don't know. My crystal ball is broken. It's in the shop trying to be fixed. But for right now, we need to get together as a team. We need to have clear, level-headed thinking, and we need to figure out what we can do next. We need to figure out what is the best plan of action for us. We need to get with our legal counsel. Property values are at an all-time high right now, today. If selling is an option, maybe that's something you want to consider. Talk to your certified public accountant about that, because you're going to have to deal with potential capital gains tax. I mean, that's something I can't even answer for you, whether you should sell or not. But remember, it's being an escrow that you can evict for right now. It's a great loophole, I promise. Anybody have any other questions? Hootie, do we have something else I can answer?
This is kind of a long one.
It's okay.
Let's see. So from March 2020 through September 30th.
No, through August 30th.
Okay. Rent is $1,000, right? So that'd be $8,000 in this case.
No, that would be 6,000. March, April, May, June, July, August, 6 months.
Okay. Let's see.
In small claims. You can sue in small claims for that 6 months of rent starting in March.
So when do we document the $6,000 and now I think I'm not sure I understand.
That's okay. Just skip to the next question. I'll review the question after this, and then I'll get back to the person that's asking.
Can I put signs up in the front of the house saying these people are squatting?
No, no. Can you? You can do anything you want to do. Would I? No. I wouldn't want them to say that I'm harassing them or have them sue me for defamation of character or anything else. I don't like going to court. Okay, just so we're clear. I don't like getting sued. I don't like defending myself in lawsuits. So why would you do something like that? You're the adult here. We need to act like one. Okay, I get it. It's not fair. It's totally not fair what's happening to us. I get it. They're squatters, they're this, they're that. I understand. But don't do something like that. You're exposing yourself to all kinds of stuff. Defamation of character, harassment, fair housing issues, yada, yada, yada. It's just not worth the risk for me. I mean, we could light our house on fire, burn it down, and collect the insurance, but that's not very business professional, is it? I mean, we don't want to do anything that's going to come back and bite us. And usually when things come back and bite us, they bite really hard with really big teeth. And I don't want any part of that. So no, if you have squatters in a property, that would be a reason for you to evict. Contact your legal counsel about what county you're in and what your options are. Serve 24-hour notice to enter. If they don't let you in, there's your first violation of the law. Build your case. It's not easy, you guys. And I'm speaking to you based on my experience. Building a case on the drama is not easy. You have to do everything in order, precisely, with precision, and have all your ducks in a row and all the documents in the row. And I'll tell you right now, do not pass go. Do not collect $200. Do not serve the 3-day notice to quit when you've got all these 3-day curable breach of covenants in place. Do not serve your 3-day notice to quit until after you talk to your legal counsel, because that's you closing the book. That's it. You don't have any more time. You have 3 days now. Get out. If you didn't have enough teeth in there, you just close the book and you have to start all over again. See how that worked? So don't serve that 3-day 3-day to quit, meaning you can do your curables, cure, quit, and reinspect, cure, quit, reinspect, but don't close that out and do the quit notice until you talk to your legal counsel. Okay. And that's me speaking from experience. I've had too many people pull that trigger too soon, and then it backfires on them. Okay. Do I have another question?
What can we do about the tenants that have a balance for the rent from March through August on February 1st?
You can't do anything to them on February 1st. Starting in March, you can then sue them in small claims court for the money they owe you for rents from February through the end of August, but not until March 1st. And I hope that answered that question. And please keep this in mind. Everybody in the entire state that is owed money is going to be in line in small claims court on March 1st. So, because your statute of limitations is 4 years on a written contract, 2 years on an oral agreement, all I'm saying is you may want to wait a few months and then file the case so that you're not in that mass, in the masses, you know? I mean, if 3 million people file a court case on the same day, how inundated and backlogged do you think the courts are going to be right out of the gate? 6 months? A year? So you may want to approach that a little bit slowly, is what I'm saying, when you're going after the money owed from March through August. Next question.
So is it a slam dunk to take back the unit for a close family member? I will be bled to death otherwise.
Nothing is a slam dunk. And that's me being honest with you. Nothing in this world is a slam dunk. I don't like to use that term. Is it more likely that you will prevail? Yes. It is more likely that you will prevail. Yes. For a family member. Depending on the county, if you're in city of LA, You do not want to go sideways. Remember, it has to be a parent, a grandparent, a great-grandparent, a child, a grandchild. You can go up your tree or down your tree, but when you start going out to aunts, uncles, cousins, brothers, and you start going this way instead of up your ladder or down your ladder, that's when you get in trouble, especially in the city of Los Angeles. Okay? No joke.
Okay, we're all set.
No joke. I'm sorry, Hootie.
We're all set.
All right, perfect. So you guys, please, I encourage you that this is Wednesdays with Widget. We have a powwow every Wednesday at noon, and we like to talk about anything that you guys need to talk about going forward. Line up your ducks for your small claims cases. Make sure you have your 30-day demand letters there. They are starting to process cases. So for those of you that are bleeding with your property right now, and we're kind of in limbo with the justice system, all those people that you've evicted in the past and you have money judgments on that are sitting there and getting dusty, we can collect on those now. Just for the record, Fast Eviction Service is a full service collection agency. You may want to call over and talk to the collections department because we are able to get those wage garnishments in place. The courts are open and they are processing those things. So although you're bleeding money with your property now, if we could be collecting money from somebody that owes you, that may help you ride out this storm. That's all I'm saying. It's just something to think about. Okay. Please go to widgetsway.com. Hootie's going to post the link to Widgets Way down there at the bottom for me. Click on that banner of bringing 2020 to a close. We are doing that webinar on the 30th at 12 noon. And look forward to seeing you all there. I anticipate having an attorney join us for their insights as well, so that we can all be on the same page, reading the same book. And remember, although we're not on the same ship, you guys, we're all in the same storm. And this is going to get much worse. And I said it, this is going to get much worse before it gets any better. Looking at them extending the 75% of the rent due until 2022 kind of tells us that. So it also prepares us for what we're probably dealing with. We have not seen the worst of this. The worst is yet to come. So buckle up, prepare yourself the best you can. I'd rather prepare you for the worst as we all hope and pray for the best, but prepare yourself, because this is going to get ugly. And the amendments that we're going to see to 3088 will paint the picture for us. So come January 29th, I'm sure we'll all have an extremely better idea of what we're in for. They say 2020 is perfect vision, but I'll tell you right now, 2020 has me questioning everything. It has been such a bizarre year. And I have a feeling that 2021 is going to put us in a whole different perspective, because it's going to be worse, not better. And I hate to tell you that, but I would rather prepare you for the worst as we all hope for the best, like I said, and we can go forward from there. Remember, if you're going to build a case on cause. Stop chasing the money. It isn't due yet. Judges are looking at weak cause cases. So you want the laundry list of everything they're doing wrong. Let your legal counsel pick out what has more teeth. It's above our pay grades, you guys. We don't know. So just give them the whole list of everything they're doing wrong. Your chain of events, document everything. Make sure all your ducks are in a row. Do your job. All right, you guys, have a wonderful week. I will see you next Wednesday here on Wednesdays with Widget. And in the meantime, if you need to reach out and contact me, you guys know how to hunt me down. Hootie did put my link down there at the bottom. Make sure that you guys sign up for that webinar on closing 2020 so that we all have a better idea of what we're looking at going forward into 2021. We should also see the amendment to AB 3088 on or before the 29th of January. Why I say that is the bill expires on a Sunday. So before close of business, the Friday before is when they have their last chance to amend that assembly bill that is affecting all of us right now. So January 29th is going to be a hell of a day unless we hear about it before then. And that could possibly happen as well. Again, my crystal ball is broken. All right, you guys, have a great weekend, a safe week. And if you need anything else from me, please feel free to hunt me down. Currently, you can find me at Fast Evict Law Group. I am there Monday through Friday for the most part, and our staff would love to help answer any questions that you may have. We are a full service law firm with our own in-house attorneys, and we are attorney owned and operated. So we're a legal firm, okay? And full service collections. So in the event that you have judgments that are sitting there collecting dust, if they were with a collection agency, they'd be collecting interest, and that would be another way that you could help stop the bleeding. I get it. Again, I'm an owner. I feel the pressure too, and these band-aids the governor's slapping on us just aren't enough right now. I get it. Hang in there. Have a wonderful week, and we'll talk soon. Bye.